Welcome today to Privacy Policies. Privacy isn't just a checkbox. We'll be chatting through what some litigation trends are involving privacy matters and what the risks are out there and how to mitigate them. This is kind of a pet topic for me. I've been on a soapbox for a while. Andrew has heard me stand on that soapbox many a time. So apologies, Andrew, for bringing you into this once again. But I know that this is a topic that's near and dear to your heart. And so I'm excited for this chance for us to talk about it, chat with others about it, um, and get the conversation out of our little echo chamber and into the broader community. So thanks for joining me for this today.
Thanks for doing it.
Yeah. So a little bit about us. Andrew, do you want to get started talking about yourself, who you are, what brings you to this topic?
Sure. I'm an independent contractor and I mostly work at the intersection of science and finance. And I get to review a multitude of business plans, some of them fantastic companies. And I do have a diligence list that I go through. And I never, ever thought to check for a privacy statement or a legal statement or all that stuff. And when Anna joined to help on diligence on a few, she brought this to my attention. And I said, well, it's nothing really major. And she said, "Oh no, au contraire. It is actually something we really need to pay attention to." So I work on projects that benefit our species 3 generations from now on a planet as it will be primarily in agriculture production. So I see all the new and novel stuff rolling out of university systems and from other countries. And again, these basics, blocking and tackling things need to be addressed. And Anna was kind enough to say yes to join us today and educate me and the rest of us on why this is important. So, Anna, who are you and what do you do?
Thanks so much. Yeah, so I am a startup attorney. I work primarily with venture capital backed companies, those that are typically in their early stages. Um, and this is a topic that has come before my desk more times than I would like to admit. So often I'm working with clients. They're preparing for a raise. They've got, their cap table in order. They've got their data room looking snazzy. But they're missing a privacy policy on their website. And sometimes this issue gets raised with investors, and when it does, it's a little bit too little, too late. And so I try to work with my clients from the get-go to think about privacy, think about what their policy is, not just kind of their, big caps privacy policy, but what their little caps privacy policy, how are they approaching it within how are they approaching policy, privacy, and data management within every level of their organization? And how are they papering their commitments to it? And so I'm excited to chat with a broader group today and keep the conversation going.
Papering their commitments to it. I'm gonna have to borrow that line.
So just a little bit of legal talk from me. The information that we're providing today is just general information, not talking about any specific legal matters involving any companies out there. There's no attorney-client relationship that's created as a result of this presentation. And any of the information in it may not be current or complete based on when you're sitting down to watch this. So please, please, please make sure that you're consulting with an appropriate counsel before you act on any information in this presentation or before refraining from acting on any information in this presentation.
It would be neat if somehow you could rephrase that in the form of a jingle, something we can say and repeat back to ourselves.
I love that idea. I'm gonna set the legal community to it. Yeah, we definitely need a more engaging way of presenting our disclaimers. Everyone's definitely sick of them by now. All right, well, to jump into the content, why privacy and why now? So often I find that companies are talking about this as just some legal fine print, some boilerplate language that needs to get tossed onto a website. They'll say, "Oh, I'll get to it down the road," or yeah, "I'll just grab something, some language from somewhere and toss it on my website." This is been an approach that's always been really troubling to me because it seems to sort of miss the point that your privacy policy is a substantive document. It needs to be reflecting a real commitment to privacy, real compliance with the regulatory landscape out there, and a system within the company as a whole that's committed to fulfilling certain privacy and data management benchmarks. So
What
I've
is, I mean, just basically, what is privacy? I mean, how do we identify that? I mean, just curious, because again, this is one of those areas that never entered my psyche until now.
Yeah. I mean, this is an area where a million different attorneys could take a different take. From my perspective, the regulatory landscape out there is most concerned with how confidential and personal information is being used or misused, used outside of the scope of the consent that was authorized by the user of the website. And so when we talk about a privacy policy, we're talking about a statement that's coming from the company that's saying, this is the data that we're collecting. This is the kind of data, the sort of categories of data that that falls into. This is how we're using it. This is how we're potentially sharing it with others. These are the opportunities that you have to do something about our use of that data if you're not happy with it. And these are kind of the promises that we make to you about how we'll engage with your data. So a privacy policy is going to look really different for every company. It needs to be specific to the practices that they're actually applying. Uh, as I was saying, this has become a real soapbox issue for me, and it's because we're seeing a lot more litigation around it. We're seeing a lot more legislation around it as well. We're seeing a lot more regulatory action. Uh, we're seeing a lot more money involved. When there's slip-ups, there's big suits that are costly, whether it's a matter of a settlement or a lawsuit payout, but we're seeing that it really is mattering to the bottom lines of businesses how they're managing data. We're also seeing that in this world where AI is at the center of everything, AI legislation is coming out that has implications for data privacy, data security, and so we need to be thinking about a broader scope of legislation when we're thinking about liability involving data and privacy. We're also seeing right now that courts are becoming a lot more sympathetic to plaintiffs' claims, and we'll go into this more in depth, but plaintiffs are coming up with more creative arguments and courts are accepting those. And so we need to be thoughtful about these new arguments. So I'll get into some more depth on those litigation trends. As I said, we're just seeing an increase in litigation in general, more suits, more expensive suits. Just last year, we saw that Google had to pay out 425 million in a privacy class action suits. These class action suits get expensive and they have a real impact on companies' bottom lines. So it's an area where we really need to be paying a lot more attention. We're also seeing in the court system expectations of more explicit consent. So where courts have permitted more sort of passive consent to certain data uses or data disclosures in the past, we're now seeing more anticipation of explicit consents, affirmative acknowledgments to specific terms that courts are expecting to see in any corporate interactions that are governed by the Electronic Communications Privacy Act. And so that's affecting companies around the country. That's a federal act. Um, we're also seeing more attention within the court system on user interface. Uh, Courts are really getting into the details of what's going on the user interface side. Sometimes they're looking at where the language is, how that the placement of that consent language relates to the placement of an action button. They're getting into the nitty-gritty, and so companies need to be thinking about the nitty-gritty. And they're also asking companies who are defendants in cases to be providing evidence of what their consent protocols looked like at the time when a plaintiff was engaging with the site. So they're asking for documentation that's real time, that's time stamped, and a lot of companies are struggling to produce this kind of evidence. So that's something that companies need to be thoughtful about.
Well, Anna, let me ask you, how do you balance that? Because when I go to websites that I'm unfamiliar with, I try to read through the terms of service, the EULA, the privacy policies, just understand what is that and reject whatever I can reject in that. That takes a lot of time. I mean, that could be 10, 15 minutes of my time just determining whether or not I want to go to a certain website. I mean, but everything that's said in there needs to be said in a specific way. So how do you balance what needs to be said versus what the user then actually has to digest and agree to or not to?
Yeah, I mean, you can take sort of a layered approach, right? So you can have a broader statement in your privacy policy, and then when users are engaging in a more active way with your site, they're actually providing personal information, whether it's through a contact us form or some other mechanism, but they're actively providing data to the site. You can have a second layer of engagement with them where you're providing more discrete consent terms that are short, sweet, get to the point, don't hide the ball, but are right there in the action that they're taking. And so, taking that layered approach is really important. Um, and that question kind of leads into also the fourth point. We're seeing a lot more enforcement when it comes to AI, children's data, and bio data. So having tiered approaches based on the kind of data that's being shared is something for companies to be working through and something for users to be really thoughtful about. Here I am on a website. I'm engaging with a chat bot about a medical issue that I'm facing. I want to be reading through those terms and conditions really carefully. I want to make sure that those terms and conditions are really accessible so that this private information about me is not being used in ways that I don't approve of. Um,
Well,
and
and
we'll
also I'll add this too. And for our listeners that are out there, I did not tell Anna what questions I was going to ask her. I just said I'm going to throw them at you. So that was not rehearsed. So I appreciate how well and thoughtful that was.
Yeah, no, thank you for keeping me on my toes, Andrew. Um, so yeah, I mean, these are issues, and we'll go into more depth, but matters involving AI, children's data, and bio data are matters that society as a whole is starting to they're concerns that are really gaining ground in society as a whole, and courts are taking notice, and regulators are taking notice and putting more attention on those matters. So, really important for companies to be thoughtful there. So, to get into a little bit more detail about clear and confirmative consent, what does that mean? And we're talking about a user consenting to the ways in which their data is being used in their interactions and any data that they're providing on the website as they interact with it, right? Um, and as I said, courts are looking at user interface a lot more closely than they did in the past. They're often demanding explicit, unambiguous consent. They're looking at how consent flows are working, what the relationship is between that pop-up box and the privacy policy, when they're weighing in on a decision. We've seen a lot of legislation that's sort of taken this course recently. In November 2025, there was a big case in federal court in California involving Adidas, where the court sat down and was looking at user consent to pixel use and was looking at the user interface there. There was a case just earlier this month involving Urban Outfitters, a case in the Washington federal court, or in one of the Washington federal courts, where the court was looking at the size of policy text. It was looking at what text was underlined, real detail into the user experience there.
Well, if you go back to that slide, and again, this was a blind spot for me, so there's no blame out there. There were a lot of companies I saw either copy and pasted or they went to a Wix GoDaddy and took the starter website package, which has a button on the bottom for privacy and a button for legal. And if you click them, they go nowhere. So but I also want to say, listen, that's not just startups. There's some companies out there that have had significant velocity and traction that this is a blind spot they have carried forward with them that's still existing out there. So this is a great time for them to go back and examine this. And we'll talk further on how do you do that within your organization. But this slide really hit me hard because I will admit I may have been or have been guilty of this as well. So Anna, thank you so much.
Yeah, no problem. No, I mean it is never too early or too late to be addressing these issues. I've seen companies that are preparing for an IPO that maybe have been um, fairly have run on pretty consistent revenue and internal funding, and now are preparing to go out into the world and seek engagement from a lot, a really broad group of stakeholders. And they haven't been paying attention to these issues, and it's gonna slow them down in the process. So never too late to be thinking about these issues. Um, to go back a little bit to the areas of focus that we're seeing within the court system, that we're seeing within the regulatory structures, uh, everyone's talking about AI, of course. Uh, and it's a real concern in the privacy world. We're seeing AI aggregate vast amounts of data. The more data that's aggregated, the greater the risk of some of that data leaking out. That data can leak out, and it can involve confidential information, personal information. It can be leaked into contexts that are unpredicted, unexpected, unprepared for. And this is creating anxiety for a lot of folks out there, and it should be creating some anxiety for companies as well. Um, and they need to be thoughtful about how this new scale of data collection and management is being handled. We're also seeing a lot of concern in our society today about how kids are engaging with tech. I'm certainly struggling through this as a parent myself, and I know a lot of parents out there are struggling with it. But regulatory agencies are really taking notice as well. Courts are taking notice. We're seeing an increased enforcement of privacy laws that are designed to protect children, particularly the COPA, the federal law that applies to children under the age of 13, and it imposes stricter consent requirements for that group. So any companies out there that are targeting children in their marketing, that are engaging with children, that know or suspect that they might have users who are children, need to be really thoughtful about COPA and about other privacy laws on the books that apply specifically to children. Um, we're also seeing an uptick in how health data is being thought about. As we were talking about before, the rise of data being shared through large scale AI networks is something that's raising some alarm. The state of Washington just passed a very comprehensive health data law that applies to data that's not covered under HIPAA. So data that's not collected specifically by healthcare entities, that's collected by other types of companies. Nevada passed a similar law. Virginia and New York have also made updates to their health privacy policies recently. So we're seeing an expansion of law on this matter, and with an expansion of law comes new scenarios and new jurisdictions where plaintiffs could be bringing claims on healthcare related matters, or in health data related matters. So something for companies, whether or not they're sort of traditional healthcare providing entities, an area where companies need to be really thoughtful right now. And And we're seeing this growth happen on the state level, on the federal level. We're seeing a mix of sort of piecemeal legislation where clauses are being added here and there to intensify the regulatory landscape. We're seeing comprehensive bills come out. States in just the past couple of years, states across the United States have put forward comprehensive legislation. Some of that was adopted in 2025. Some of that is expected to be adopted in 2026. So by the end of the year, we're looking at a regulatory landscape that looks different from the one today. Um, we're also seeing that enforcement outside of the US is on the rise. So Europe has always had a comprehensive, or for the last 2 decades, has had a really comprehensive data regulation framework under the GDPR. And we're seeing a lot more enforcement of claims brought under GDPR, particularly in the Netherlands and Germany. And it's important for companies to be thoughtful about this. Sometimes companies will say, "Oh, I'm a US company. Why does the GDPR matter to me?" But it does. If you're collecting data from any European residents, you're using that data, your activities could potentially be implicated by GDPR. So it's important to be thoughtful about that even as a US company. And then again, we're seeing the rise of AI regulation, and a lot of it deals with privacy in one way or another. So don't stop with compliance, on strict kind of privacy policies. Look at other policies that could have privacy implications as well. As I said before, plaintiffs are becoming more creative in the claims that they're bringing to court. And so companies need to be thoughtful about how to prevent against these evolving novel claims and how to defend against them. We're seeing a rise in common law negligence theories, which is really interesting. We haven't seen a significant case law history in the past. But now people are starting to assert.
What's common law?
Yeah, so common law is the law that goes through the court system. It's not a statute. It's not based on a law that's been passed by a legislature. It's the law that exists within the court system that's been reinforced by decades and decades of litigation. And when we talk about common law negligence, we're talking about the legal theory that's based on four main factors: that an entity has a duty to another individual, that the defendant had a duty to the plaintiff, that duty was breached somewhere along the way in the relationship between the defendant and the plaintiff. That there was causation, so it was actually a result of the defendant's actions that the plaintiff had an injury of some sort, and that there are damages to be shown, that injury is can be calculated, that there's evidence to support that injury. Um, and so this is something we see in torts cases, your typical kind of trip and spill cases. But this line of reasoning is being brought to the privacy world as well. And plaintiffs are claiming uh, that companies have a duty to safeguard the data of their users from any unauthorized disclosures to third parties. And there's courts that have shown some sympathy to these kinds of arguments and are permitting them in court. So it's something that we need to be looking to as well, not just the statute, but the common law history there too.
And I'm going to borrow a trip and spill too. Thank you.
No problem. Um, Another thing that we're seeing is class actions, and this really matters because there's a lot of money behind class actions. We're seeing that plaintiffs are asserting claims on the basis of privacy, misuse of private information when it comes to really common tools, cookies, tracking pixels, that sort of thing, and that they're implicating state privacy laws. We're seeing the California Consumer Privacy Act come up in a lot of litigation. Um, and that act can apply to companies that aren't even based out of California, but are using and collecting, processing the information of California residents. So it's something for companies that are based and incorporated all around the country to be really thoughtful about. And again, and thoughtful about what the bill could be at the end of the day for engaging in these kinds of suits. So you alluded to some of this before, Andrew, some of the big mistakes that people are making when it comes to their privacy policies. I'm shocked the number of times I see people cut and paste a policy. Sometimes they don't even remove the name of the other company that they took the policy from.
Well, let me ask
Um,
you this. I mean, would that be a copyright infringement issue?
It could be. It really could be. That's intellectual property potentially that the other company is distributing out into the world and has ownership of and has rights to protection to. And so not only are you kind of, creating trouble for yourself from a privacy perspective, but you're creating trouble for yourself from an intellectual property perspective as well. Um, and to go back to why is this a problem from a privacy perspective? You're not distributing a policy that reflects the actual practices of the company. You're reflecting the potentially the practices of another company, but not those of your own company. And so you can't stand behind those practices. In a court, that privacy policy is just going to get torn to shreds, and isn't going to do you very much good. Um, we're also seeing situations where there's policy and practice mismatch. So maybe you didn't directly cut and paste a privacy policy, but you used, one of these kind of boilerplate policies. You grabbed something from a website, you put your own company name on it, um, and you said, all right, this is good enough. It's not good enough. It's going to lead to some liability down the road potentially. When you don't have consistency between the words on the paper, the privacy policy itself, and what your privacy program is, your privacy policy is just a worthless piece of paper. It doesn't reflect actual practices, and so it doesn't reflect your actual relationships with your users. Um, as we said before, sometimes we're seeing conflicting terms. So there might be inconsistent terms within a privacy policy. There might be inconsistent terms between a privacy policy and other agreements that a company has. Um, these can really undermine trust. It can create confusion for your user, and make them question which terms apply, and it creates confusion for the courts. And courts are very prejudiced against those kinds of conflicting terms. Um, and then another issue that we're seeing is compliance gaps. So as we were talking about before, companies may think, oh, I'm not in California. California privacy law doesn't apply to me. I'm not in Europe. European privacy law doesn't apply to me. That's not always the case. It depends on whose data you're collecting and how you're using that data. And we're seeing regulators are really jumping in on these issues. We're seeing a lot more attention from the SEC, from the FTC. Where, they're not letting these things slide. They want to make sure that companies that are using data that implicates a certain jurisdiction are complying with the laws of that jurisdiction.
And courts don't like confusion.
They do not know. They may create some confusion, but but they don't like seeing it come up in their docket. So building a strong privacy program. So I've used the term program here intentionally. The data privacy infrastructure of a company goes well beyond the privacy policy, that document that's on the website. It needs to be a really comprehensive program that's implicating sort of your legal infrastructure and your operational infrastructure. You need to make sure that players within your organization, that partners outside of your organization are on board with your privacy program. And really important as you're working to build trust with customers and investors, you're asking them to join on to your vision for this company, that you're using clear, plain language, that you're not hiding the ball, that you're making it easy for them to understand how their data is being used, how their data is potentially being shared, and what their rights are with respect to it. Um, so, Andrew, I'm going to pass the baton to you because we're now going to head into some practical steps that companies out there can take. And I know that you have a lot of experience in this domain and can give them a lot more practical guidance than I can. So, please take it away.
Sure. Thank you. And I appreciate everything you've covered so far. Back earlier in my career, I worked in strategic digital marketing, and there are so many free tools out there that you can run any kind of audit that you possibly need on your own website, on your pretty much any of your digital assets that you have out there to look for these types of misalignments. I mean, the easiest I can think of is the broken link. So if you have a broken link from a privacy policy or a legal policy somewhere, that should right now be a red flag and a white hot burning fire that needs to be addressed immediately. And then the policy and practices piece, we'll get into that in a second, but thank you.
Yeah. And so you're saying that these free policies out there will actually catch the
Well,
mistakes
it's
and
not a
help
policy.
them
It's
to
more of
detect.
an app, a third-party app or
Okay.
website that you can go to and put your URL in there, and it will flag everything that's possibly wrong with your website. And it's going to be looking more for broken links, broken backlinks. Not only the things that the user is going to see, or the user of that website is going to see, but also the back-end engine. So if there's any code that's wrong, or again, they're fairly robust. And if you are in website management, it's always good to have one of these tools. SEM Rush is one that a lot of folks like, but there's others out there as well.
Terrific. Thanks, Andrew. That's helpful. And so practical step two, take it away.
Yeah, all right. Well, so it's not only encrypting sensitive data. So if you're, and I'm going to use the folks out there seeking investment, seeking equity funding. If you are out there and you've got a click here to see our slide deck, but enter your information to see so, and you don't have a privacy statement or a legal statement, that for me would be just terrifying. At least knowing now what I know. So they say you need to have your data encrypted at rest and transit. Basically, the entire domain of that data needs to be encrypted so no third party can find it. It's crucial that your staff understands that all of your data that you're collecting needs to be protected. If it's customer data, I strongly recommend you have a multi-factor authentication to that, and only collect the data you're going to use. Don't have a lot of superfluous data out there because you might get tripped up on something like that. Make sure you have good data hygiene so when you no longer need that, it can be deleted. Don't let anyone view this data. I mean, there's so many stories out there, people getting their hands caught in the cookie jar because they went in there to see about someone they wanted to, I don't know, maybe have a relationship with or get to know better for some particular reason. Don't assume that your employees understand any of these rules and why they matter. So make sure this is part of your training. You can make it part of a monthly meeting that you have, a staff meeting of some sort, or make it part of the onboarding process and have an updated privacy training every year. And then the basic stuff, you want to patch your systems, make sure they're always updated. Apply these same rules and standards to any of your third-party vendors. Make sure that they are protecting data too, because if they come in there and have access to your data, but they don't have the same sort of privacy thresholds that you do, that could create a conflict as well.
Yeah, such great points, particularly on the third party vendors. I really work in when I'm negotiating with third party vendors to make sure that they have clauses in any agreements that ensure that they're meeting the same standards that the company itself is meeting. If you're working with a vendor and they slip up, that data that you've guaranteed to protect for your users uh, gets out there in the world and is subject to liabilities that you can be penalized for. So super important in those conversations. Sometimes people think, oh, well, like my own house is, I've done the internal housekeeping, everything's in check, but they don't think about the partners that they're working with.
Yeah, and to the second point there, you want to make sure when people come to your website, that little lock is up there to make sure it is a secure website. And one of the things I went back to when I talked about before, the terms of service and EULA and all those things, the privacy policies, that's what I read when someone wants to put cookies on there. My typical response for me is reject all. If I can find it in there, and if not, I turn everything off that doesn't necessarily need to be there. But you'd be surprised how many websites will opt you into things if you don't go through there and uncheck those boxes as well. So if you are deploying cookies, maybe you know it, maybe you don't, maybe the third-party website vendor you have is doing these things. If you don't have an appropriate way for people to manage those, you could be at risk of some liability.
Great points. Yeah. And then on to practical step three. I'll just reiterate some of the points I made before, but super important that there's alignment between across all policies and with any other agreements and operations. You can have a beautiful privacy policy. Every I is dotted, every T is crossed. But if you're then signing vendor agreements and those don't align with your privacy policy, then you're in some trouble. So really make sure that you're working with your attorney on getting uniformity, consistency in terms across all documents.
And I have a question for you. This presentation so far has been how to protect yourself from litigation. And a lot of that litigation or some of that litigation could be spurned from a cyber attack where someone has taken that data and done something to it that's wrong. Question for you. Knowing that that's going to be a higher and higher probability as we go on through time, would it be a good step to include some sort of proactive language in your privacy policy in the event of a data breach? Here's how we handle each sort of state, or here are the thresholds. Do you think that would be something that'd be useful? I just thought of that as you were speaking.
Yeah, absolutely. It's such a good point. And I find so often people will say, oh, I don't really need to be worrying about this because I'm a good actor, because I'm not improperly using data, because I'm being thoughtful about these things, because I'm not trying to sell massive amounts of personal information out there. Um, But at the end of the day, it's you can only control so much. You can be subject to cyber attacks. You can have links to websites on your site, and those websites can be subject to cyber attacks. So there is a lot that's outside of your control. And yes, I mean, I definitely encourage incorporating terms that prepare for those kinds of eventualities.
And to the team training piece, I love doing tabletop exercises. That might be an interesting one for someone to put into their monthly management or staff meetings is, hey, we just had a cyber attack and all of our data is gone and it's been released to the public. What happens next? Who speaks to the press? Who speaks to the police? What are the different state? Because every state's going to have a different threshold for when those letters have to go out to announce a data breach. That would be an interesting process to go through, and it helps them then build an incident response plan, which is always critical in this environment.
Yeah, absolutely. Yeah, I mean, and just to kind of go back to the cost piece, I think sometimes people don't think, okay, they think oh, maybe there'll be regulatory fines if I run into trouble, maybe there'll be litigation costs, but they don't think about how much cost that mitigation plan take, how much cost is involved in implementing that remediation plan. And they don't think about the lost business that results from having one of these kinds of cybersecurity incidents. So really important to be preparing in any training sessions for all of those possibilities. And then insurance. You and I chatted a bit about this. I know that this comes up. It's a
This is
question
going to
for
be a
you.
4-hour presentation
Yeah.
on this one slide alone. I love the risk management topic as well, but go ahead there. Again, I'll chime in.
Yeah, I mean, just you again, you can do everything you can do and you can still run into issues, right? So it's super important to put into place those operational mechanisms that are going to mitigate the risk of a cybersecurity or privacy breach occurrence. It's super important to have a privacy policy that communicates to your users what you're going to do, what their rights and responsibilities are. Um, but it's also important to have, another option if those first attempts fall through, a way to transfer any residual risk and to protect your company from a lot of those data breach costs that we were talking about. Um, and so I always encourage my clients to sit down and chat with a qualified insurance advisor and sort of guide them through what level of coverage they might want to consider at what time. But interested to hear from you, Andrew, if you have additional thoughts on all that.
Well, if they're not asking about your privacy and legal policies in their checklist as they do their diligence for your renewal policies, or if you're getting a new policy, shame on them because they will. I mean, this is something that is it's a landmine that people need to be aware of. The other piece too about cyber insurance, should you have that as a business owner or head of an organization, make sure those documents are not on your computer network. They're what they call air gap. They're on a piece of paper that's in a drawer. They're on a thumb drive somewhere. They're on a disk somewhere, but they're not on your system because when the cyber criminals get into your computer systems, that's the first thing they look for. Well, the second thing they look for. The first thing they look for are your backups. They destroy those. And then they go for insurance documents because they want to find out how much coverage do you have in the event of a ransomware attack. Then they execute their attack. They deploy their customer service reps to call you up. And then they instruct you to call your insurance company and put their customer service reps on there and they negotiate whatever that is. So you can interrupt it's a kill chain. You can interrupt that step by having an air gap there from your financial documents. And another thing too, in addition to cyber, and I know I'd love to talk more about this with a different webinar. I really encourage people to start looking at terror and war riders on their insurance policies because some of these cyber attacks might be part of a war effort, in which case that cyber insurance policy probably won't cover whatever damage has been done from that. So just going back to Anna's suggestion there, find someone that knows what they're doing, ask them some hard questions, some of those over the horizon or nearshore questions, and go from there.
Yeah, that's such a great point, Andrew. And I think goes to an overarching piece of advice that I often give my clients is to really spend the time sitting down, reading through any policies that you're signing on to. There can be those exceptions and exclusions written into them that could be really costly down the road. So important to be thoughtful about what is and what is not excluded and make sure that you have coverage for the things that you really need coverage for. Um, so privacy. So we've given a lot of doom and gloom stories here. A lot of these are the risks and these are the potential costs. What's the upside to all of this? I think a plus side that people often miss is the fact that because a lot of companies are doing this wrong and it's really easy to do it right, they can gain market advantage by doing it right, by just spending a little bit of time and money up front to get the right procedures in place, get the right policies in place, and prevent the slip ups that their competitors are running into. It's pretty fast, it's pretty easy, it's pretty inexpensive to do prevention. That story is not the case when it comes to remediation and defense. So,
Well, the other thing I
that's
look
what
at,
I
it's
think.
like going into battle. You don't want to go into battle with your armor with great gaping holes in it, or papered over holes that you thought were there. If you go into battle with that full gear on, you're much better off. So I really think that's the advantage as well. And again, like you say, it's so simple.
Yeah. Yeah. Yeah, it's definitely a matter of right, making sure that all those gaps are filled. Um, so there's kind of the obvious things, reducing lawsuits, reducing regulatory risks that come with implementing a strong privacy policy from the get-go. As we've hinted out throughout the presentation, it's also a great opportunity to boost your brand, to build trust in your brand amongst customers, amongst investors. When investors are going to your website, when they're looking through your pitch, you wanna make sure that everything looks good. It's clear that you have a solid team behind you. It's clear that you're thinking through risk. It's clear that you're a team that they want to be playing for, right? You're taking the necessary moves to keep the company safe and sustainable in the long term. And that can, one way of doing that is through your privacy policy. And as we said before, as your competitors are forking out a lot of money to pay for regulatory fines or litigation fees or remediation costs or whatever it may be, you can be putting those resources towards bringing in some of their customers when they slip up. So it can be a real opportunity to have a competitive edge. And I think that's pretty much it. Any questions that you have for me? I know I've got some questions for you, Andrew. Any questions from the attendees out there?
No, it's just deafening applause is all I hear at this point in time. So, no, it's hard for me to have a question that was so thorough. I mean, that was down to a granular level. I do want to extrapolate a little bit on the AI point because this is an area of concern in multiple categories. Sometimes that AI, unbeknownst to you, has already data mined whatever that is, and who knows where that information is going. Was it a small subset and never travels outside your server, or is this something where you use a different tool to assist you in that process? And then what are the privacy rights that are behind that tool as well? So another topic for another day, but you really got me thinking about that one.
Yeah, absolutely. And I think it's something that it's something the legal community is talking about a lot. And I hope that folks within the business community are starting to talk about it a lot more and starting to think about what are the risks that are coming along with AI use. We talk a lot about some of the big societal implications for change in workforce and impact on workflows, but talking also about the kind of micro level of the impact of AI and what it does on the data level and what some potential casualties of that could be is really
Yeah,
important.
I mean, just think about it. If you were a malicious lawyer, you could create an AI agent that went out there to find every company that revenues over $10 million a year that lacks a privacy policy or legal policy or has something that's copy and pasted and just plop it into the lawsuit machine.
Yeah, yeah. I mean, that's scary. And I mean, I think that's starting to happen. There's ambulance chasers of all sorts. They gave our profession a bad name. And if it's not already happening, it soon will be. So something for companies to be wary of for sure.
Now, did you have a few questions for me?
Yeah, I was interested in sort of hearing what you're seeing on a day-to-day basis. What are you seeing to be the most costly data privacy threats? Uh, where should the companies that you're working with really put any resources that they have to devote to this subject?
There's two answers to this question. One is very simple. It's just do what you said. Check your stuff, audit it, make sure we're good, train your employees, do those things. What I'm seeing a lot more of now is corporate espionage, team on team and nation state on us, where people will get in there and they'll use that data to their advantage financially or economically, um, either unbeknownst or beknownst after the fact to those people. And I think that all goes back to that hygiene piece that we talked about before, just making sure employees know where your crown jewels are and they're encrypted.
Yeah, such great points. And yeah, on that crown jewels, I mean, thinking about what also are the targets that plaintiffs are going after these days, and what areas of company data are most susceptible to litigation, I think is really important. Yeah, and just sort of you talked a little bit about uh, apps out there that will scan through websites and identify gaps. Can you talk about a little, some other programs that are free or programs that offer a really high ROI?
Um, SEM Rush is one that I've used all the time, but I'm kind of reluctant to name other names because I really haven't done that many deep dives on websites in the age of AI, in the age of more mature AI. And I'm sure there's AI tools out there that would do a much better job. Now, like other geeky people, I will go to Reddit and see what the comments are and see what people have to say and go from there. So that's my non-answer for you.
It makes a good point, though. I mean, there's so much that we can be doing now with AI to make sure that we're addressing these risks, right? If I want to run a program myself to identify risks, I can do that. Um, in this age of micro entrepreneurship, there's a way to find a solution without having to pay a lot of money for it. But of course, that has to come with a lot of sort of careful calculation and awareness of what your own limitations of understanding of the scenario are, right? I find so often in the my work with clients that there'll be an expectation that I can plug some legal quandary into ChatGPT or Claude and it will pop out an answer that a lawyer will give me. And so I wish that that would be true. It would make my job a lot easier. But that's not where we are. So often we're seeing hallucinated cases. We're seeing legal advice that doesn't reflect the context of the legal scenario at hand. And so I know that that applies on the data management side of things as well. That it's really important to bring in an expert when expert advice is needed.
And even if you're using AI, read it. I mean, I had the pleasure of reviewing a very long white paper, and some of the citations I felt were like, I haven't heard that claim before, and went and tracked it down. It was a citation of a citation, and sure enough, the other citation said the opposite of what the claim was in the document. And so, yes, to your point there, I mean, not only hallucinating case law, and I was smiling as you were saying that. I'm thinking, boy, I hate to be a physician now. Can you imagine all the patients bringing the conflicting thing? I'd take a lot of vitamin A or something like that to cure my measles, and have them go to the hospital for that.
Yeah, yeah. No, it's scary stuff. It's scary stuff. And we're definitely entering into a world where there's so much more opportunity to do things on an individual level, but in some ways there's even more of a need for expert guidance because so much of the information that's being passed around these days is false. Um, and if you could tell me a little bit too, Andrew, about you work specifically in the ag sector a lot of the time, and I'm interested to hear what you're seeing in the ag sector, how these issues are similar or different with the companies that you're working with there.
I think it's an enormous blind spot. And again, this is why I've asked you to do this so early on, is to get this information out there. So those companies that are in the space, and again, it's not a fault, it's just a blind spot. And once it's addressed and once it's known, it can be taken care of. Very similar to when I preach secure by design. If you're building a robot or writing a computer program, just make sure you've thought about security as a top five thing in there. This fits right into that whole stack as well. Security, privacy, because these are no longer line 50 or line 60 on the to-do list. These are top-notch items. And again, not just particularly for the litigation purposes, but also for the cyber environment that we're in right now too.
Absolutely. And you bring up a really important point about how iterative these processes need to be. I see this in my works early on in a company's formation. They'll sit down with an attorney, they'll get a privacy policy drafted up, they'll have a privacy plan built into their operations, and it looks good and it works really well for a few years, and then they evolve and things change and they bring on a bunch of new staff members and they have new partnerships and their product changes. And the systems that they had in place years before just aren't up to the job. And so it's a process that's constantly evolving. It's important to put on your calendar every couple of years to sit down and reanalyze where your cybersecurity, data privacy risks stand and create plans for addressing them in that moment.
That's a
So,
really good idea. Put it on a regular cadence. I think every 8 months, every year, just how fast things are changing.
yeah, absolutely. And it's something too, I mean, to go back to the early stage startups who feel like this is overwhelming and they just don't have the time or the capacity. I often encourage clients just to put a date on the calendar that's their data privacy and security date. That's the day they're going to sit down and think through their operations, think through where the gaps are, and create a plan. And it doesn't have to be some big, 6 month, 9 month program. They It's a great idea to get started with just, an 8 hour workday devoted to the subject with a plan for follow-up. So again, never too early or too late to get started on this. Terrific.
Good, and thanks for filling the air there as my video froze.
Oh no, no worries, no
I'm
worries.
back.
Great. Anything else that you want to add? Any other questions?
I think that is it. We hinted at a few future programs that we could do. If you have a unique interest that falls outside of the things that we talked about, we'd love to hear from you. Again, as I said at the beginning, these are instructive both for the greater audience, but also for me. These are my questions, and I had the great honor of asking a friend like Anna to come and tell me everything she knows, and then we record it and put it out there for you guys as well. And Anna, let's say that somebody is very concerned at this point in time and wants to reach out to you in a very discreet manner, how would they get you?
Yeah, well, that leads us nicely to our next slide. Feel free to reach out to us, connect with us on LinkedIn, or you can shoot me an email there at anna@proprietarylegal.com. And if you've got questions for Andrew, I'll pass them along to him as well. Uh, but we're always happy to start the conversation here. It's one of those things where sometimes people are afraid to even start the conversation because they don't want to be reminded of all of the blind spots that they've had. But there's a lot of little steps that can be taken, both from the operational perspective and from the legal perspective, that can go a long way in reducing a lot of these liabilities. So thank you so much, Andrew, for being a part of this conversation. I've learned a ton from you. I see these things from the legal perspective. I see how they fall on paper, but I don't often see the operational side of it all. So great to have your insights there. And looking forward to keeping the conversation going with you and with our attendees and anyone else viewing this video in the future. And yeah, take care.
Yeah, and I guess one last thing, fun fact, because we'll answer the question before we're asked. We are not related. It's just happenstance that Rose is in her name. But thank you so much, Anna. Again, I appreciate you taking some time today to go over this wonderful topic.
No problem. Take care. Bye bye.